Yeah, so I'm gonna launch this here. As Charles and I were talking about putting together something like this a couple of months back, we actually talked about having a high amount of integrity to this process, just making sure that we actually bring something of great value to all those who attend. Are you guys able to see the slideshow beginning?
Yep, we see it.
Okay, from the beginning. There we go. Okay. Charles, I need some other control because it ain't letting me navigate it.
Well, you should be able to. As long as you got screen control, you should.
All right. Try this.
Your arrows, move your arrows, be able to move it.
See, I could do this, right? But my front and center slide is not coming front and center.
Or did you start for, this is a PowerPoint, I assume?
Yeah, it is. It is a PowerPoint.
All right. You should have all the options to be able to run it.
Click on the next slide. You maybe just click on the left column.
Yeah.
Click on the left
So you're not running the PowerPoint, you're running the slides instead.
Yeah. No, it's not doing it. Present online from current slide from beginning. See, this is where it starts off. Resume slideshow.
From the beginning, and then you should just be able to click to be able to make it work. You don't see that?
Hold on, let me save it and let me try it again. Let me launch it again.
Okay.
And it is right in here. Sorry, guys. Maybe this will help me get it started. Slideshow. There we go. Perfect. Okay. Guys, good afternoon. My name is Ben Assad Mirza. Today, we're going to be indulging you into healthcare mergers and acquisitions. And actually, I am joined today with Ed Myers and my associate and my niece, Komal Mirza. Komal, you want to walk us through the legalese of our seminar first?
Sure. So, good afternoon. My name is Komal Mirza, as Ben introduced me. I am an associate attorney with Healthcare Law Partners, and today's seminar is about mergers and acquisitions. It's really a roadmap for strategy officers, administrators, general counsels, and physicianpreneurs, and how to navigate mergers and acquisitions. Please keep in mind that this presentation is intended to be generally informational and educational. It's not legal advice in any way, shape, or form. So if you have any questions, concerns, or if you would like a consultation, I really encourage all of you or any of you to reach out and contact us. And we'd be happy to help you out in any way that we can. With that being said, I'd like to turn the presentation over to Ben and Ed.
Great.
So just by way of background, I've got about several degrees and a few certifications. I tend to actually collect them almost like people collect cars. I collect diplomas, and I don't have many cars, but I do have a lot of diplomas. I do have a bachelor's in accounting. I have a LLM in tax law, primarily focusing on corporate mergers and acquisitions. And I've been at a whole variety of different organizations, including places like Broward Health, and I've practiced in the area of healthcare for a number of years now. Ed, you want to make your introduction?
Yeah, so I'm Ed Meyer. I'm a practicing healthcare lawyer for about 30 years, coming up next year, my 30th year in healthcare law. I attended Georgetown for my law, Stanford for my undergrad, and I spent a year freezing to death in upstate New York at Cornell University, where I did a graduate studies in government. But I actually worked, before I even became a lawyer, I was working in Washington, D.C. For a member of the Ways and Means Committee, and then for the Reagan administration as the U.S. Department of Health and Human Services. As I said back then, I was rather low level, but I would pour coffee, who poured coffee for the guy who poured coffee for the president. So that's kind of where I was back in the scheme of things in the Reagan administration. But it gave me a great focus of my career dealing with healthcare. And so I have worked in various organizations in healthcare. I had various types of clients. And when Ben and Charles and I were talking about this project, we realized, and I really think I can contribute to the discussion of merger and acquisitions. I've handled several and worked on several healthcare mergers and acquisitions, from small rural hospitals to large health systems. And I want to make sure that this focus does include a focus of the middle management, because that's sort of an area that everyone kind of focuses on the high C-suite level, but there's a middle management area of focus that needs to be focused on, and they need to understand what the process is. So again, this talk is going to be more of a very much of a 30,000 foot talk going down to the very small levels. The slides are very much oriented to an understanding of the process, so that folks who know there's a transaction going on have a better understanding of what to expect and what they'll see during the course of the negotiations, through closing, through operations.
All right, with that said, let's start off with actually what's in play today. What's been happening over the last decade is there's been an obvious shift in payment structures. The way that payments are being structured, primarily from the government side, is the one that's actually driving it. And we're going to much more of a ACO format, meaning like the HMO, ACO, aggregate players that are controlling the way healthcare access is accessed. Now, with that said, there's also a change in technology, not only just in telehealth, but also in remote patient monitoring, and the way people are being diagnosed and the way devices are being connected. And so that's changing the way healthcare is being delivered. That now you couple those two things with cheap capital, because capital has gotten cheaper and cheaper over the years. There's a lot of money to be exchanged here, and there's a potential for some higher level of profitability that the acquirer or the target might actually get. As we're going through this COVID crisis, there has not been as much M&A activity going on. And that's also true if you actually look at this chart. This is a chart from HFMA, and it was put together by them and Deloitte. And the last time the study was done was in 2017/18. So really the data in here is up to 2016. And what they noted later on was in 2019, the activity was down. And we also know that in 2020, the activity is down, the M&A activity. So what that's really doing is that it's building up pressure for more M&A to happen in the next upcoming years, in whether it's 2021 or 2022. What they're predicting in the state of Florida, a lot of the strategic experts, is eventually there will be 5 to 10 major players in the state. There will be less and less of these smaller pockets. We're going to start consolidating these healthcare systems, and that's coming down the pike. So you take all of those pressures, you combine it with like the COVID and the low physician morale. I mean, now the environment has become completely ripe for M&A activities. It's just we just got to get through COVID, and it's going to open up. And that's why I think you guys are so timely, and the seminar is so timely in attending, because this is the time to prepare for that. And exactly. Today, what we're going to actually discuss with you is not just how timely this is, but also like the roadmap of how you go there from point A to point Z. We're going to first walk you through the actual timeline of how this stuff will happen. We're going to walk you through what is involved and all of the intricacies of what you need to be looking out for. And last but not least, we're going to talk about the middle management perspective and how people can actually adapt and change and endure through the M&A activity that's going to happen. So starting off first things first, mergers and acquisitions is really a dance. It's a dance between the buyer and the seller. So what the buyer is trying to do is actually leave as much of the liabilities behind and only buy the good assets. And what the sellers are trying to do is shift over as much of the responsibility to the buyers. So it's really a dance. So depending on what sort of an entity, what sort of business it is, there's typically 3 structures that'll follow. One is either an asset acquisition, where all you do is purchase the good stuff like the real estate, the supplies and inventory, the deposits, the client list, the licenses, the permits. That's all your good stuff, money producing stuff. The second option that a buyer will have, or a seller will have, is to do a stock acquisition, which essentially means that it's going to be a merger. It's typically the larger player swallowing the smaller player. But that's not always true. You can also have the smaller player sometimes buy the larger player. So that's going to be in play. The third option is to actually even do joint ventures, or to do a partial equity stake. Now, there's actually some plays that have been made so far in our state where people are actually buying partial stakes in other entities and consolidating, aggregating these healthcare providers. The last but not least, which is off sheet, is really a management agreement. Ed, you want to explain a little bit about the management agreement?
Yeah, I've done several management agreements. Now, keep in mind that each of these, asset acquisition, stock, or joint venture, management agreement, or even like a lease of a hospital, they're also very much driven by legal requirements and legal issues. So, for example, first on the asset acquisition, if you're acquiring just the assets of a hospital, Medicare very much will go and say, okay, well, now we got to recertify the hospital. So this is why that you don't see asset acquisitions being done as much in the hospital sphere, because then you have to get recertified, and you're not going to get paid for several months. And I've heard of some acquisitions where they didn't realize that, and also they acquired under an asset deal in a hospital, and then they realize they're not going to get the income flow on the Medicare patient treatment. So that's one thing. That's keep that in mind. On the management piece, keep in mind that the manager is just the manager, and that if that manager is managing or owns a competing hospital, there is still antitrust restrictions on both. So keep in mind, two entities together can't collude if they're separate. I mean, two entities that are separate can't collude, and the managers of those can't collude on set prices. So there's certain care that needs to be given if you're going down that management route to make sure that it's appropriate structure. Again, all these are done via consulting.
So,
next slide, please. Yeah.
before we begin down the roadmap, I think a part of what's important to discuss, and Ed will walk you through this, is how to go about positioning yourself. What do you do before, what to do before you actually start? So starting before you start, Ed.
Right. So this is great. It's very, very important before a hospital that's selling or thinking about aligning with another system really positions itself well before going into the transaction, or even floating it, that they're going to want a suitor to buy them or to acquire them. And it's like when you sell a house, you're not going to just say, put a sign in front of your house and sit there in your shorts and a t-shirt drinking a beer while the buyer is going to come through. We're looking at your house. You're going to want to clean it up, get it well positioned, understand the strengths and the weaknesses of your house. And same thing with a hospital. You're going to want to get your business in order. You want to obtain perhaps a valuation and have an idea of what the asking price should be. You're going to want to look at your contracts and certain key contracts that are going to be asked for, to see if there's any constraints or issues with them. Perhaps you want to fix those problems beforehand, and agree who the negotiating team is going to be, and who's on that, and make sure people are going to speak with one voice and know what your bottom line is. The negotiating team, who's the lead business person, the decision maker, obviously the CEO. Oh, but who else is on that team? Who the attorneys, the accountants, the valuation consultants, and any other sort of manager that's on that. Again, keeping in mind that it hasn't moved forward, and this is still preliminary, so it's a very small group that keeps things confidential. And if you're a small rural hospital, they're going to be acquired, you want to look to see, is there a way you can actually create some leverage, so you're not on the track of just at the will of the potential buyer. And that could be through doing an RFP process, for example. Also, we're going to be talking later. After I look in a moment, we're talking about the timeline. Then we're going to talk about due diligence. But I want to make sure that people look at these due diligence checklists, because you're going to know what people are going to ask for. And so you know what's out there. You get all those documents perhaps in order. And one little piece, it's very, very helpful. This is going to be a very complex endeavor. There's going to be emails flying back and forth. In fact, someone once told me that acquiring a hospital is more complex than acquiring a nuclear power plant. If you think about it, there's a lot more moving pieces to a hospital than there are to a nuclear power plant, more regulatory issues and things like that. So, but there's going to be emails going back and forth. So a very good tactic very early on is to come to an agreement on the email protocols, so that when emails go back and forth, you know that this email is about this transaction, and this email in the subject line is about a particular subset of the transaction, where you are in the timeline. In addition, your checklist, make sure your documents are going to be put together in order, so they're all in one place and in a room there people can look through them, and in a very methodical way to streamline everything. So next slide. Now, we're going to now talk about the timeline. Now, there's a lot of pieces here. We have 20 steps that we identify, and the purpose of these slides is to give just a picture of things you'll see over the transaction timeline. Some of these things occur early on. Some of these things occur at the same time. Some of these steps are very confidential, and so only a limited number of people actually know what's going on, because the deal hasn't yet been struck. It's not publicly announced. And so, but especially from a middle management point of view, they may be seeing bits and pieces of these deals and may be asked for information dealing with each of these steps. And so this is I think is the helpful set of steps to kind of understand what's there. So, at the very beginning, after you've maybe looked at and got your house somewhat in order, there's the matchmaking process. Who are the potential suitors, some discussions, but before those discussions actually take place between parties, there's a non-disclosure agreement that are signed between the parties, saying, we're going to be exchanging some information, and we're not going to, you can't disclose it, you can't use it, and you have to, other than for evaluating the transaction, and you need at the end of this to destroy or return all these documents. In addition, because a potential suitor may be a current competitor, there's going to be a need to have a third party, the buyer, potential buyer who's looking at possibly doing this, is going to have like a third party evaluate documents for them, so there's not an exchange of competitively sensitive information between competitors, but exchange is going up to the consultants that are then going down to the management. So then you sign this non-disclosure agreement. People start looking at it. They're looking at it. There's some initial exchange of information. The management starts looking at what might happen, and again, there's some initial due diligence. There's some very initial due diligence where you're looking at the payer mix. They're looking at key contracts. They're looking at the organizational structure. What sort of their subsidiaries out there. The general issues to evaluate whether or not the buyer was really willing to entertain a transaction, and then to basically structure the big deal pieces, that the purchase price and things. Next slide. So that's what's going on at the very, very beginning of it. And then there's that more exchange of information and documents. Then you get to the point, and again, this is all going on at the senior level. A very small group of people know this, what's going on, because it hasn't occurred yet. It's not been publicly announced. Then you're going on to the letter of intent stage. And this is where they're negotiating the actual big picture pieces of that the parties have decided, yes, if certain things occur, they will actually abide it by the hospital. Same thing as a physician practice. The letter of intent is very, very helpful. The letter of intent is usually non-binding. It's not binding, but it's a moral obligation to continue on. And that letter of intent will, in what I've always suggested, is have a term sheet to it that provides the broad terms of that'll end up in the final agreement. And from a small practice of a small hospital trying to get leverage, letter of intent stage is actually an area where leverage can be happen for the final agreement, because you might be able to put in that letter of intent certain things that protect the seller, such as reps and warranties will be standardized, common, it's used in transactions rather than detailed reps and warranties. You may add certain functions in it, and a timeline that makes sense for everyone. So that's in the letter of intent. And now they've signed a letter of intent. Now people know, your business folks know that the parties desire to come to a final agreement. Again, they have not come to a final agreement, so there's still that antitrust restrictions that are going on. But now there's a deep dive as they're going from 8 to 10, from the deep dive to actually write the agreement. So how are you going to make sure you write the agreement correctly? So you're going to look, the attorneys are going to look, the accountants are going to look, the valuation consultants are going to look, the management is going to look deeply at the seller's contracts and licenses and all those things that are necessary to actually write the final document and identify what needs to be taken care of to be able to do the transaction. And as they look through this deep dive due diligence, there may be some reevaluation of the purchase price, or let's say, for example, the purchase price says X dollars, and they're identifying in this deep dive that there is some liability out there that needs to be taken care of. So there may be a holdback of dollars that need to be placed in the final transaction, but it informs what needs to be in that final written agreement. And it might also be that as they're looking at documents, that there's a need to add more due diligence. Maybe they realize that there's a subsidiary they hadn't really focused on, and then they really want to acquire as part of that. So they may add due diligence pieces to that. Next slide, please. So then they get to the written agreement. So they have the final contract and they say, we're signing this contract. Now that contract itself doesn't say, yes, it's happening. It says if certain conditions are met, then it closes and it's created. It also says what are the reps and warranties. Now that the written contract may not actually be signed at that time, but the words of it are there. So for example, there'll be reps and warranties, we'll talk about in a moment, that'll be made, and schedules created that list out exactly what's being purchased and list out what's being accepted, taken out of a representation as an exception. Who are the employees, who are the key employees, and what are the systems. So there's, and what are the regulatory filings that are there. So there's, after they have this agreement in place and ready to go, that there's this movement from regulatory paperwork going to assimilating of data, and not just the people working on the actual finalizing agreement, but the business people now are getting more involved in looking to see what is going to, how they're going to put the hospital or if it's a physician practice together with the new entity, the buyer, keeping in mind that you have not yet closed. Since you have not yet closed and finalized a transaction, you may still be competitors, and there has to be something in place to be able to take sure that if the deal falls apart at the last minute, then all that inside information about how you operate is not used by the buyer in the future. So then you create the schedules. What do you mean by creating schedules? So the contract itself is going to have all these reps and warranties in the agreement. I'm going to represent a warrant about start compliance and all these other things. And there's schedules that are going to be the exceptions that I've identified, that if we rep and warrant, here's all our contracts. So there's a schedule listing all the contracts, that there's not something we haven't shown you. Rep and warrant that all our contracts are enforceable. Well, maybe you've looked at some, you didn't have a signed contract. So you identify that on a schedule. Well, we have this arrangement, it's not signed. Then the people can evaluate that. So there's these schedules that are everything that's there necessary. Here's all our licenses, for example. Here's another thing. Here's all our licenses. So they know all the things that need to be done to finalize the transaction. Next slide. So then you get, to get really close to closing and say we've actually now acquired it, is you obtain the opinions from the attorney, legal counsel, that the contract's enforceable. If this is a nonprofit hospital, that they an opinion from the bond counsel that they have met their, there's no issue with the tax exempt nature of the bonds of the seller. And then there's the funding of the transaction, the wire transfer. And then all those documents are signed by the parties. Everything is signed. All this, like if you need to transfer licenses, all those transfer arrangements are signed, everything. And then the attorneys look through the whole set of documents and the bill of sale, and they say, yes, everything is together, do the wire transfer, and now we could record the deeds, we could record and make all our filings, and it is closed. It is actually a pretty silent thing that, I've been to these closings where there's like these boxes of signed documents and the attorneys go, yep. And again, all those are held in escrow until the council says, both sides council say, yes, we have everything. We're now closing, abracadabra. Now it has occurred as of this moment. And then before you go to 19 and 20, there's a very important little piece I have not put in there, and that is the closing dinner that occurs oftentimes. That it's very important to invite the attorneys for a nice steak. You don't have to, but it's a nice gesture.
Or a drink. A drink would be.
Yeah. So there's a closing. So there's basically, what actually I'm joking a little bit about that, because now you're taking two separate organizations. You do want to put something together that get people together. So there's a esprit de corps between the two entities, because a lot of what's happened is it happened in the background. And what you need to do is you need to operationalize what you just acquired. And you need to transfer knowledge as you move forward to operationalize that between the parties. So you need to transfer the knowledge that you've done in due diligence, your schedules and things, to the operations folks. And oftentimes what I've seen is sort of the closing occurs and those who are involved in the transaction kind of move on. And then also some people have to operationalize it. They don't realize that, oh, we realize X, Y, and Z about this contract or about this key employee or something like that, that you just need to know about to be able to move it forward quickly. So that's where, and then obviously the announcement and making sure the patients know, and then that you've not lost business because of that. So let me move now. Now we talked about the big steps that occur, is this issue of the due diligence, because this is such an important area. Checklists are created. It's important to understand that when one's acquiring, be it a hospital, be it a for-profit versus nonprofit, be it a physician practice, be it a home health agency, a pharmacy, a lab, that these checklists of documents necessary and to understand it and understand the transaction, understand the nature of the business being acquired, they're very much tailored to that particular type of business. So for example, so physician practice, there may be 60 items that are necessary to see, 60 or types of contracts, leases and on business records and things like that. And then when you go to a small hospital to a larger health system, that list may grow to up to 400 even items. Again, if it's a for-profit versus nonprofit, knowing the nature of the entity being acquired, it's important to know that the nonprofit, you got to add things that are specific for nonprofit entities, and they're like the bond covenants, tax exemption issues, looking to see whether or not the hospital has availed itself to the immediate intermediate sanctions provisions that gives a rebuttal presumption that the arrangement was okay. Things like that shows how they operated. Similarly, pharmacies, there's other issues that are very pharmacy specific. So it's important to have these early on to tailor these checklists as you're moving forward. So what's in? Next one, let's talk about what are sort of the things you're going to see in these due diligence checklists.
Before we go on, just the way to actually structure these checklists is a lot of times you'll have like a master list, and especially if you're like acquiring a entity that has multiple different divisions of business, to create subsets of those lists. So you have a master list and you have sub lists, and those sub lists help you check off the master list. So whenever we've done them in the past, we've done them through Excel schedules, Excel files, where you actually run the schedules on that, who you're assigning these tasks to, and also what your concerns are on each single individual check item. So, okay.
And so what is going to be asked for? Now, it's very important to be very well organized, because these lists, like I say, go from 60 to several hundred items that might be required. And different people are going to be asking it for different reasons, different people who are working on the transaction. So the attorney is going to be looking at, let's say, corporate records for a certain reason. The accountants will be looking at for another reason. Different people, let's say dealing with managed care contracts, may want to look at certain things. Different people may be asking for the same document. And from a middle management point of view, what happens is that it's very possible that someone might ask for a document. Say an attorney might ask for a document. I need to get this document, right? And then someone else asked for the exact same document for another purpose. So from the management point of view, someone's going, I already gave that document up. I already gave. So it's just, and they're going, why are you asking for me again? Well, they don't really know. And oftentimes because it's early in the transaction, it's very confidential. You can't really say. So you want to make sure that your files are organized very carefully. And there's a depository of where these documents are so that those working on the transaction can access them from a centralized location. But the things that are going to be asked for obviously are, the corporate. Let me look at the company itself, the entity. Are the articles of incorporation, the articles, bylaws, board minutes. They're going to look at the board minutes for approvals, for making sure it's been operated correctly. And again, part of that early on cleaning up items, this may be a physician practice, and perhaps you haven't really formalized your board minutes. So you want to make sure that stuff, knowing they're going to be asking for these things, make sure that that's all taken care of well in advance. Similarly, your org structures, how does that? You have an org chart, make sure that's all put together. Key employees, your financial statements, this is all the stuff that's going to be asked for. List of assets, real estate, equipment, your managed care contracts. Again, some of the stuff is very confidential and cannot be exchanged directly with the buyer if they're a competitor or a potential competitor. And next slide. More things are going to be asked for. All your regulatory filings, your debt instruments. What are your bond covenants? If you're a nonprofit, your finance or tax exempt bonds. Are there anything in there that someone needs to flag? Title, to license title to property. Is there anything in that you got to do title searches? Is there anything that might be some restriction? For example, if the property was donated by someone and it says something that if this hospital is ever acquired by certain types of entities, then that goes back to the owners. Things like that. You got to make sure people will be looking at. So obviously beforehand, you need to see it. You need to look and consider there's an issue. Your billing, computers, personnel, staff, etc. Next slide.
One more thing to actually just add to that is, as you're looking at personnel, if there's an excluded individual in one of the entities, that may very well negate the whole entire transaction just because there's been stuff that's going on under that entity's nose with a excluded individual involved. So just be very mindful and careful of that, because excluded individuals are a real threat to any acquisition that could potentially happen.
And again, I want to note that I've been talking mostly with regard to the buyer looking at things, but the seller may also want to be looking at things and seeing if there's an issue. For example, is there going to be a problem? Are they going to be able to operationalize it? Because again, many of these may be smaller hospitals that have a devotion to their communities and want to make sure there's not something about the buyer that's going to be problematic, or if they think there is, how are they going to work through it so that it's an easier shift once the sale occurs. Now, I want to talk now about the whole issue of reps and warranties, because that's a big area of the final agreement that folks are going to need to know who are looking at these transactions, that these are reps and warranties are going to have to be made by the seller. They're going to have to say, I have this company, this hospital, or if it's a physician practice, is compliant with all the STAR clause, compliant with the anti-kickback statute, compliant with all the other provisions of Medicare or Medicaid, if they're funded through that, that there's no one excluded, that they've met all HIPAA requirements. There's no EMTALA problems. There's no False Claims Act. They're going to make all these reps and warranties. And I mentioned schedules because they may come across something that this is a breach of this warranty. So they're going to want to schedule out as an exception and then negotiate those schedules. Look, if there's a Stark law problem that they've scheduled that out and then perhaps shifted that risk over to kept it if the seller buyer's going to want to have them keep it at the seller point of view, or set aside money if there's going to be a problem, or have them fix it and address it before there's a closing. So these are reps and warranties are going to be made that are going to be compliant with all these laws. The next slide, please. And if years ago you got Hilburton money, then you got to make sure you've met the requirements for charity care, that your financial statements that are in there are correct. Again, because the reps and warranties shift risk between the parties. Because if there's a violation of the rep and warranty, then the buyer could say, I don't want my money back, or I want pieces of my money back. Government enforcement actions, you're going to say, here's everything that's ever occurred. Here's all the letters we've had, anything the government's looked at us for. So people, you're making a rep and warranty that there's not an existing enforcement action, or if there is, I've disclosed it. So no one says, well, there's a surprise, I never knew about this. Similarly, bond covenants and loans, these are all going to be warranted that you've met your bond covenants, except if there's an exception, then you've addressed it. And then moving on to beginning, like we mentioned earlier, you're going to get to these regulatory filings. All these filings are going to have to be made. Like I mentioned earlier, it's more complex to acquire a hospital than to acquire a nuclear power plant. So there's, all these scores. And so in these due diligence, in these reps and warranties, you've now disclosed, here's all the licenses that are necessary to operate all the departments and everything they do. Now, all these licenses are going to have to be moved over. So you're going to have that all lined up with these agencies and signed off, so that at closing, all these licenses are now moved from one entity to the other. Yep. Next slide. Oh yeah, these are all the one last thing. If it's a huge transaction, $92 billion or above, you got to go to the FTC. And then, so finally, we want to talk about the regulatory, we want to talk about the middle management. So go to the last slide there. So middle management doesn't necessarily know what's going on throughout the transaction. They may not hear bits and pieces. And it's very possible that people get worried. They get very nervous about their positions. And key employees in the middle management or down may be leaving because there's uncertainty. People don't know whether they still have a job. They don't know what's going to happen to their benefits. There could be disruptions in the workforce. So one has to really recognize that and be able to address it early on. At some point, you keep in mind things are still confidential. So, but as Ben mentioned, there's great opportunities here for middle management as you're doing through the transaction.
Yeah, so you have to actually, as middle managers and lower management and even staff is involved, there's actually, it's almost like a fork in the road when they're going through a due diligence period. There's a level of resistance that the employee can offer because they don't like the change, or they can view it as an opportunity. If you notice the slide, it's got the word opportunity underlined twice. And that's because I think that there is an actual opportunity at the time of when there's first an exchange of information. There's an opportunity for the employees, the middle management staff, to show how much they actually know, have knowledge of, can put together, collaborate, be easy to get along with, and all that sort of stuff. Like, it's really good, like team play. That's a great opportunity in the middle of the due diligence period. The second time, if and when it arises, it's going to be the second time is going to be after the acquisition has already occurred. And then it's going to be time to assimilate those operations into the organization. That's another time to show that the middle management is actually open for this new opportunity to actually bring in the new lines of business. And the more knowledge they can show, the more cooperability they can show, the more hands-on sort of a role that they play, the more likely they are to actually stick around after this transaction has happened. And that's one way to actually really add up some bonus points when you're going through this. The psychology here is really important to understand. It's going to affect a lot of people in the organizations. I mean, I've seen several of these reorgs happen from the internal perspective, and there is a level of resistance that occurs naturally inside an individual or an employee. Just have to be mindful of it. make sure that you push it to the side and see it as an opportunity, and that the whole entire employee population sees it as an opportunity.
And also one last final point too is senior management, as they're looking at this, may not yet have determined how everything's going to come together. They, even when you get after closing, they may still be figuring out who is in which slots for it. They may not know exactly what is going to happen, which can be disruptive. But again, that's kind of the nature of what happens. So.
Personal benefits. I think Ed was talking about this a little while ago. Personal benefits will also be affected, and that's people's personal egg, right? So they'll be very watchful.
There's a lot of questions. You'd expect a lot of questions. What's going to happen to my accrued vacation? What's going to happen to my benefits? How are the benefits changing? So HR plays a real important role in the transition to the new owner.
Yeah.
So.
With that said, I think we've actually covered a pretty nice 30,000 foot level, and we did a deep dive into what you could be expecting on a timeline. We've talked about what to expect on like due diligence checklists. We've talked about the regulatory environment that's going to be impacting this transaction. It's a pretty long road at any time a entity goes down the M&A road. With that said, for all those who are attending, we'll be sending you out personally a due diligence checklist for a physician's practice. If you are looking to buy or sell a physician's practice, we think that that's going to be helpful. If you need more checklists for other unique situations, we do have more. We have a lot more, and we have a whole bank of them. So, let us know on that front. If you, pretty soon we'll have this same due diligence checklist posted on our resources page. So if you go there, probably tomorrow it'll be up as well. But today I'll shoot out everybody a list of the due diligence checklist.
Yeah. It gives you a better idea how to get your house in order as you approach these transactions.
If anybody has any questions, this is probably a good time to raise them. Otherwise, I think we're just about up on our time limit. So.
Ben, let me throw out a question for the group. If you are a middle management person and you kind of find out after documents have been signed and agreements have been made, truly what effect do you have on this besides really just taking the fallout?
That's a good question. Can keep in mind that you may have, and keep in mind you have institutional knowledge that is very necessary for operations, and that institutional knowledge gives you value to the extent you still have it and haven't given it all away. So
well, I think that brings up the whole idea of, well, why don't you sit down with Charles and he'll tell you how this entire operation runs, and then at the end of the day,
Charles is gone.
Charles is real nice. We know what we need and you're gone.
Right.
I mean, is there a way that an employee, without being disgruntled, without being non-cooperative, has a way to be able to protect themselves in a situation?
Yeah, well, what often happens in certain key employees that are necessary to keep it moving, that might give an opportunity. The employee say, hey, look, I'm going to get another job. You're going to be asked to leave, or you're a very good chance, and say, okay, for X dollars, I need a contract that says you're going to keep me on for this period of time. I will stay here for a certain period of days, certain period of time. And if I stay here through that period of time and provide the information, I get a special bonus.
Now, is there any obligation, and now we're getting into deep weeds here, is there any obligation from that middle management person to be cooperative and give everything they know about their position, or do they carry a stick, or is it just kind of, well, just empty me out and I'm done, throw me away? Is there anything they have that they can say, listen, this is what I don't want to do that. You can if this is your desire, you can contract with me or keep me on.
Right. Well, keep in mind that employees have, a duty to the employer. So they have a continuing duty, and they're not there to sabotage the company or not provide information. But then there was a war in the 1860s, I recall, that this ended involuntary servitude and slavery. So people are free to leave.
Right.
People can, get another job and leave or quit, or that's what happens. So that could be disruptive. So you have to, up through the point that you remain employed, you have to cooperate. But again, a person who has the key information and key value to the company can, seek some sort of leverage, saying, "Hey, I have to look for a job. I know I'm going to be going, but if I stay here for the next 60 days, 90 days, through that period of time, I want to get a bonus. Otherwise, I'm not. Just so you know, I'm looking. I'm going to be gone as soon as I find something else."
Well, or they would deal with an employee who knows they're not going to be kept, could
Right.
just they just kind of leave. And if they want information, they can contact them or pay them for the information, I would assume.
Or pay them to be a consultant.
Right,
They
exactly.
can do that, but
Okay.
they don't have to cooperate unless there's an agreement. They're no longer employed.
Right.
They don't have to cooperate.
Right. Okay.
Unless they had a prior employment contract that addressed that.
Right. Okay.
So now, I think our next seminar that's coming up is about fraud and abuse and the resources that are available in the open space. And we're going to be putting that together in about 2 weeks. That's coming up. And that'll be really informative for all of you legal people and administrators too,
Right.
on here. And so keep an eye out for that. Do register for it. It's going to be at the same time 2 Tuesdays from now.
Right. It'll be on if I'm looking at the calendar, on the 17th. On 17th at noon, and you'll see that on the emails that go out on my list. Ben will send you the checklist update, and we'll have that link on there to register early. Are there any questions anybody has? There has to be at least 1 or 2 questions. Anybody?
Charles, I have a question. I'm wondering, when the hospitals are doing an M&A, how much due diligence do they do on each client's financials? So when they do the financials, are they essentially blending the financials, or are they doing some financial planning, i.e., do they project cost savings by consolidating FTEs or departments? Do they project increased revenue by having more of a market dominance or expanded structures or services?
I can take a shot at that one. Yeah, overall, they are actually taking a look at the overall combination, how it'll impact cost structures as well as employees. And the funny thing is, everybody has expected through a merger or through a more consolidated entity for there to be a cost savings. But when you take a look at what the HFMA and Deloitte study shows, it shows that there's actually an increase in costs and the delivery of healthcare. So even though consolidation is happening, it's intended to drive down cost structures. In the end, what it's amounted to, and I think CMS even did a study on this, is that the cost structure has gone up, or cost line items have gone up.
Interesting. Thanks, Ben.
Mm-hmm.
Question. Charles Eric Hunt from Advanced Dermatology. My question is as follows. We're a large physician practice group with about 350 doctors and 150 offices. One of the things we're running into with COVID-19, and we've always shied away from these in the past, is the earnout concept. Because with COVID-19 now, when you're trying to do the due diligence on financials, obviously as you start to do comparatives, you're not going to have the same financial runway that you would normally see because of COVID-19. So getting a lot of pressure from the ops team, and we have done a couple deals since COVID-19 where we've allowed some earnout calculations as long as we're excluding government payers from the calculation. But what's your thoughts on that? And is the government going to be a little more, favorable to an earnout because of COVID-19, if you're truly just trying to measure the financials and pay people the value of their practice?
Again, I understand what you're talking about. It's post-acquisition continued payments going to a physician in the referrals, who's a referral source. And that's what you're talking about in the earnout.
Yeah, exactly.
Which implicates the kickback statute.
Correct.
And the Stark statute. Now, keep in mind, right now, there's certain waivers that are out there. I don't believe that there's a waiver on that earnout piece. So the statutes are the statutes. And unless the government changes the statute, or unless the Inspector General office issues a regulation or a advisory opinion about it, they take that potential for an earnout as influencing referrals, because the physicians are still practicing and they're going to want to look at there's that danger that the government's identified in various opinions, and that the fact that they believe the physician needs to continue having revenues into that entity to be able to get that earnout. So I myself don't think that is going to be something that the government's going to say, yeah, sure, no problem. And I guess it's a problem because a lot of these structures, these compensation structures, were put in place without thinking that there could be this complete stop of elective surgeries, a complete stop of certain types of care, a restructuring basically of how the care is delivered that affects it. So that is something, like I talked about at the very beginning, looking about how you're going to deal with this, that again, there's going to be a purchase price. You're going to buy a practice, practice is going to be purchased, and how you're going to address it to meet those regulatory compliance issues. But yeah, that's a very good question. It's going to be very difficult to overcome.
You haven't found a great solution to that, because as a general counsel and chief compliance officer, it's always easy to say no to things, and I hate doing that. I like to find reasonable solutions and workarounds, but this is a tough one.
Yeah.
Right, the statute hasn't changed, no exceptions have been made. Typically, an earnout, if it includes government payers, is going to be frowned upon.
Yeah, but there is ways to deal with it, but you have to it has to be in the acquisition agreement itself. That might be a delay in the purchase price based upon meeting certain thresholds, as long as there's certain, there's ways. I mean, I can't really give advice right now, but there are certain ways to look at this.
Eric, I would suggest, Eric, that you give Ed or Ben a call and just kind of have a quick conversation, and maybe there's something that that they can help you with.
Thank you.
Again, we are in waters that nobody thought we'd ever be in, and business deals that have been made may not make any sense, and unfortunately, there are still rules and regulations, and is somebody willing to take a risk of saying, well, this is more than reasonable based on what's going on, except if it ever goes to court and the judge says no, you're dead. So it's it's tough to say what would be reasonable even with all this going on.
It's all good until it's not good.
That's right. People say, well, this is real reasonable based on the times, and then 3 years goes by and people say, well, that really, in hindsight, that really wasn't a good thing. It's like, well, okay, it's difficult. I mean, looking at situations today and then trying to take a look at them a year from now, after you've been able to think about it a whole lot, people forget that you have to make decisions on the fly, and unfortunately, that doesn't always work.
Yeah.
Right.
This is Bookie. Have a quick question. First of all, great presentation, Ben and Ed.
Thank you.
Thank you so much for the information that you provided. About that physician who is a little ambivalent about entering this space in the first place, just because they're not quite sure or informed enough about what their future holds, whether it's a near future or long-term future about M&As. Do you have resources to advise them, accordingly?
What was the last word about what to expect, or
maybe just is helping them evaluate if being acquired is a viable option in the first place, right? So that kind of precedes, looking at going into the market and looking for partners, if you will.
Yeah. I mean, again, keep in mind that we're going to have a separate section later on of just on physician-specific areas. But yeah, talking about physicians, I've done a lot of physician acquisitions. The physicians need to understand that they're selling their practice, someone else owns it. So you have to be able to know that there's a different owner, and you're now an employee. You have to make that cross that Rubicon, saying I'm an employee, and I will now answer to the employer. The evaluation is done oftentimes based on the compensation, on whether how long that new employment agreement is going to be lasting. If you're selling a practice, what the value of that practice is when you sell it to them, how much money you're going to get for the practice. But then again, knowing that that buyer has now paid X dollars for it, and they're going to want to, make sure they get value for what they paid for. But yeah, there's certain things that the physician needs to think through. And again, part of it too is just wanting to simply to practice medicine without having to deal with the headache of all the management pieces that might be answered by the type of company that's buying them, and also looking at that structure of the buyer. Does that buyer have the right structure that they understand physician practices? That's one of the issues that you see in the hospital areas, whereas hospitals could be strong if they have strong physician management of physician practices, or they could be weak if they don't have physicians in that structure, in the management structure. So there's a whole evaluation that needs to go into place.
And I think the other thing from a standpoint, from an accounting standpoint, you need to, if a physician is looking to sell a practice or be bought out and now become an employee, you got to get the financial advisors and accountants, the business evaluation people, the attorneys, even when you're thinking about doing it, to see if there's anything there to do it. If you wake up one day and somebody comes in and want to buy your practice, the price may sound reasonable, but it may not make any sense in the long term for that physician. So I think once a physician makes that decision, like selling any business, you need to take a look at, are you continuing in the business? Are you just dumping the business? But you got to get your team around you. It's a team sport. That your attorney, your business evaluation person, and your accountant could be the same person, but you got to get those three people in the room to figure out what is your best opportunity in this. And that goes for whether it be a physician, a hospital, or it could be the drugstore down the block. It doesn't make any difference. You got to get those three people in the room so you're moving in the right directions. Right.
Very early on, you got to get the accountants involved because they understand the numbers.
Right.
One of our slides was literally about how to create curb appeal earlier on in this session. Bucky, if you'd like a copy of the presentation, I'm happy to send it to you, and I can also send you other stuff that'll help you get physician practice groups prepared to go to market.
Right. That's as long as they use Ben and Edward as their attorneys when they go to market. Otherwise, you get nothing. So
it'll be very kind, but it's okay.
Very kind, Charles.
We're happy to provide the information, however you decide.
Yeah. But I think it's important to really, when you wake up that one morning and you're thinking about doing this, is to get the right people around you to be able to really see if that's the right decision to be able to be made.
Yeah. Because it's a big decision. You're changing where you are. You're going to be signing non-competes, and you'll be stuck.
Right.
Stuck. If you're not happy, you got to maybe move. You have to have them move.
Yeah, the non-competes are.
And there have been a lot of physicians that after a year or two really regret what they've done. So you really need to see. You got to look into the future and make sure that you're going to be happy with that.
And talk to the other physicians that are in that practice. So,
right.
How comfortable are they? How comfortable are they with this?
Yeah. Well, we're bucking up against the hour, so go ahead.
Hi, I'm sorry. This is Rosa Maria Herves. Would it be possible for you to share the slides with us?
Sure. Yeah. No worries. Yeah, if you, Rosa, I'll put you down as well. Book. Anybody else want slides or?
Thank you. Very, very
okay,
interesting.
Sure. Eric as well. Got it. Okay.
Very interesting.
Okay, I'll send it to you guys. Okay, no worries.
Thank you.
Yeah, it's got a nice timeline, and I think it's nice to share it with your management team, because that timeline helps them walk through mentally what's going to happen to the organization. Then that due diligence checklist overview that we have, I mean, that's a pretty nice way to actually even open up your own internal management discussions as they start to occur. These slides have in it your talking pieces as to what you need to prepare your teams for. So
excellent. Thank you.
Okay.
Thank you.
All
right, guys. Thank you.
Last words, Ben, Ed. Last words.
No, just thanks for being here. I look forward to next 2 weeks from now on our next presentation. Again, Charles, thank you for having us do this for folks. And you know, we hopefully this has been helpful to people, help you understand as you're moving forward and looking at evaluating what the next steps are, what to expect. But great.
Right. So
And
my last words are a little bit less serious. Everybody grab a bucket of popcorn tonight and sit down by the TV and enjoy yourselves, because we don't get this every year, right? So
No, we don't.
enjoy it.
This
Enjoy
is
it.
And just
it was like the full moon on Halloween, right? Same thing. Didn't happen in how many years? 50 years. So
I think Komal has something to add. Yeah, go ahead.
Yeah, I just wanted to ask that if there are any attorneys left on this Zoom call, to please send me an email at komal@healthcareattorney.net. I am going ahead and applying for a CLE credit with the Florida Bar. And if you would like the CLE credit, please shoot me an email and I'll make sure to get it out to you.
great. Thank you. All right. And again,
Thank you.
for future events, we are trying to get continuing education credits, and we'll let you know as those materialize.
Charles, the question is for you. Do we get CEs for FASCI for this ones or no?
The answer is no, we do not. I am working on that with the local chapter, Rosa, and as we move forward, the information, the presentation information, or the information about the event will indicate whether we have it or not. I would say, again, this is obviously, if anything would be qualified, you might, if you have the slides, you might want to send the presentation on yourself to ACHI and see if they would make it and accept it as qualified. I don't know. At this point in time, we don't have approval.
Rosa, we've been trying to get, ACHI approval, and I believe on the one that we have coming up for the 17th,
we may
have approval for that.
We don't know. We may.
We're inching closer, but
Right.
Obviously these seminars are literally intended to be straight up, informational and full of a lot of stuff and a lot of really good nuts and bolts stuff. And so we're really actually trying that, and hopefully ACHI will see it. But ACHI's a larger organization. They need some
Right.
time to kind of think through
Right.
So it's coming.
So
It's
we'll know hopefully within the next week whether the next one will be, and if it is, as you see my emails, I'm sure you see my emails go out, Rosa. It'll be indicated on there that would be the qualified credit. So
Thank you so much.
thank you
Thank you, guys.
everybody for coming.
Thanks, sir.
If you have
Thanks,
any
Scott.
questions, the information is out
Thanks,
there.
Bucky. Thanks, Jamal.
You know how to get a hold of me.
Appreciate it.
And thank you very much for coming in.
Take care, Greg.
Thank you.
Okay.
Bye-bye.
Bye, guys.